My dear friends, my colleagues in legal profession, civic rights activists, defenders of democracy, and my fellow citizens, in the recent wake of the developments that have triggered serious constitutional reflection when the Honorable Supreme Court of India declined to entertain the petitions under Article 32 of the Indian Constitution concerning the alleged hate speech of Himant Biswa Sharma, I would like to share my views on the importance of Article 32 of the Indian Constitution, the Supreme Court's constitutional duty, and the test of institutional consistency. My friends, the framers of the Indian Constitution did not create fundamental rights as ornamental promises. They ensured that those rights were backed by enforceable remedies. It was this foundational concern that led Baba Sahib Dr. B.R. Ambedkar, the father of Indian Constitution, to insist upon a constitutional mechanism through which citizens directly approach the Supreme Court when their fundamental rights were violated. The mechanism became Article 32. Ambedkar was unequivocal. Rights are nothing unless remedies are provided whereby people can seek to obtain redress when their rights are invaded. He went further and described Article 32 as the heart and soul of the Constitution. Without it, he said, the Constitutional would be a nullity. Then, my friends, Article 32 was not framed as a matter of judicial convenience. It was conceived as a guaranteed remedy, a direct constitutional right, a shield against executive excesses. Executive excesses means government excess, a structural limitation on state power, that is government power. The power of judicial review, later affirmed as a part of the basic structure doctrine in Keshavananda Bharati versus State of Kerala case, necessarily includes the vitality of Article 32. If judicial review is the basic to the Constitution, the primary remedy to enforce it cannot be treated as an optional or reluctant. The Supreme Court has historically described itself as a sentinel on the qui vive. A sentinel does not choose its movements of vigilance selectively. My friends, the question of consistency, but because the recent developments which have triggered serious constitutional reflection while declining petitions under Article 32 concerning alleged hate speech by Himant Biswa Sharma, the Honorable Chief Justice of India expressed concern that it was being turned into a political battleground and the high courts were being bypassed. Encouraging litigants to approach high courts under Article 226 is constitutionally sound. High courts possess wide and current jurisdiction. However, a critical concern arises when Article 32 petitions in some politically sensitive matters are declined, while other Article 32 petitions continue to be entertained. And suo motu cognizance is also taken in issues such as the recent controversy involving National Council of Educational Research and Training NCERT Class 8 textbook chapter on corruption in the judiciary. One may substantially agree with the court's intervention in NCERT matter. The issue here is not the correctness of that order. The issue is constitutional consistency. If the court expresses impatience at being directly approached under Article 32 in one case, it actively exercises jurisdiction in others, and an appearance of inconsistency emerges. In constitutional adjudication, appearance matters almost as much as substance. My friends, the risk of perception. Courts derive authority not merely from the constitutional text, but from public confidence. When Article 32 jurisdiction appears selectively exercised, it risks generating an unfortunate perception that the court may be deferring to the ruling executive or that it is consciously avoiding matters that would displease those in power. Even if such perceptions are unfounded, institutional credibility demands that they be avoided. Ambedkar envisioned Article 32 as a weapon in the hands of the citizens against potential misuse of political power by the governments. It was meant precisely for moments when the executive or the government is strong and citizens are vulnerable. To hesitate in such movements undermines the moral architecture of the Constitution. My friends, Ambedkar warned that the political democracy would be hollow without social democracy, a way of life founded on liberty, equality, and fraternity. Hate speech corrodes fraternity. Executive indifference weakens equality. Then judicial reluctance chills liberty. The constitution structure assumes that when one organ falters, the another will step forward. Article 32 is the instrument through which the judiciary fulfills that stabilizing function. In Bandhwa Mukti Morcha versus Union of India, the court expanded access to Article 32, holding that the procedural technicalities cannot defeat substantive justice. It emphasized that where fundamental rights are at stake, the Supreme Court cannot adopt a hyper-technical or evasive approach. Thus, historically, Article 32 has been treated not as a discretionary grace, but as a constitutional obligation. My friends, independence beyond structure. Over the decade, the Supreme Court has reshaped judicial appointments under Article 124 to preserve independence, particularly through developments culminating in the collegium system, but structural independence alone is insufficient. Judicial independence ultimately rests upon courage in constitutional movements, consistency in principle, equal treatment of causes, and fidelity to constitutional vision. Article 32 is not a matter of grace, my friends. It is a constitutional command. Then, in S.P. Gupta versus Union of India, the court liberalized locus standi, holding that any public-spirited individual may approach the court to vindicate constitutional rights of those unable to do so themselves. Public interest litigation system, the jurisprudence, emerged precisely because of the court recognized that access to the justice must be widened, not narrowed. Further, in Navtej Singh Johar versus Union of India, the court emphasized constitutional morality over majoritarian impulses. The judgment reaffirmed that the courts must protect fundamental rights even when political climates are unfavorable. If constitutional morality demands courage in unpopular cases, Article 32 becomes the vehicle of that courage. Then, my friends, selectivity and institutional perception. Encouraging litigants to approach High Court under Article 226 is constitutionally permissible. High courts possess vast jurisdiction. However, constitutional consistency demands that Article 32 not appear selectively upon. When certain politically sensitive petitions are declined with remarks that the court should not become a political battleground, while other equally sensitive matters are entertained or even taken up so moto, including the recent controversy involving NCRT, a perception of inconsistency may arise. The issue is not correctness of the individual orders. The issue is uniformity of constitutional principle. Courts function not only through the authority, but through the legitimacy. Legitimacy depends upon consistency. My friends, Article 32 as a duty, not as a discretion. In Minerva Mills versus Union of India, the court held that the limited government and judicial review are central to the constitutional identity. Article 32, therefore, is not optional. It is a part of that identity. Supreme Court may evolve prudential rules. It may discourage forum shopping. It may balance institutional workload, but it cannot appear to abdicate its constitutional role in matters alleging grave fundamental rights violations, especially when those allegations concern high constitutional authorities. Ambedkar trusted that the judiciary would remain insulated from the executive influence. If today there is even a perception that the court is deferring to the executive power or avoiding displeasure, that perception must be addressed not rhetorically, but institutionally through consistent constitutional engagement. My friend, our hope is rooted in constitutional faith. The Supreme Court has in its finest hours defended civil liberties against overwhelming state or government power. It expanded Article 21, strengthened equality, and declared judicial review part of the basic structure. We hope that the recent observations cautioning against becoming a political battleground will not evolve into a doctrine of constitutional retreat. The court need not enter politics, but it must never vacate constitutional ground. Article 32 is not merely a provision, it is the heartbeat of the Republic. heartbeat of the Republic's promise. If that heartbeat remains steady, constitutional democracy endures. If it falters, rights risk becoming ornamental. The choice, as always, lies in constitutional fidelity. Article 32 is the heart and soul of the Constitution, and that constitutional duty cannot be selectively exercised. For in safeguarding Article 32, the court safeguards not only itself, but also the Indian Republic itself. Thank you, my friends. Jai Bhim, Jai Bharat, Jai Constitution.